So the International Human Rights course from a Global South perspective is really intended to bring to the students the idea of thinking about human rights and looking at human rights not from a northern perspective. Human rights law, the whole theory of human rights law was developed in the global north. When we talk about the treaties and the human rights conventions and covenants, it's primarily led by countries in the global north. What we wanted to do in this course is to bring a global south perspective. The perspective of countries that are, from the global south that are the most affected by the human rights policies, but also affected by the human rights violations. So thinking about violations of human rights, the global south is primarily the recipient, if you will, of the human rights violations. When we think about, for example, the environment, when we look at the rules regarding the environment, they are primarily dictated by the north and the impacts are felt in the south. But also when we talk about disappeared, the problem of people who are disappeared, if we look at the Latin America, that's primarily, those are the countries that are primarily affected by the issue of disappeared people. For example, in particular, Mexico, that has 26,000 people that have been disappeared in a democracy. So from that perspective, yes, the global south, the global south countries are really the countries that are most affected by human rights violations. So during the course, it was a short course, only 15 hours to cover the entirety of human rights law. So it was really, the intention was really to do an overview of human rights violations. So we started with an overview of human rights law, looking at the treaties, looking at the UN system, looking at regional systems, the regional system, the European regional system, the African system for the protection of human rights, and also the inter-American system, both the Commission and the Court. So that was the first theme, big theme, doing this general overview. Then we went into more specific rights. For example, we dealt with the disappeared. We looked at the first case of the Inter-American Court, dealing with the disappeared, but also with the very first case of that the Inter-American Court ruled, and it became a landmark case. So we looked at the decision in that case, the facts, but also the impact of that case, not only for the Inter-American region, but also the impact it had in the European Union and later on the African system. So we started with that, looking at disappeared in the 70s and 80s, and then we looked at disappeared now. We looked at the case of Ayotzinapa in Mexico, that 43 students were disappeared about 18 months ago, and what the role of the Inter-American Commission has been. So we looked at the Inter-American Court and Commission in the 80s, we looked at the Inter-American Court and Commission now, and the role, how it has changed, how it has evolved, and also the impact of the international system and the work in that regard. We also looked at, for example, torture, and what is happening in different parts of the world relating to torture, and also particularly after the war on terror and the jurisprudence that came out of the war on terror. We looked specifically at the case of El Masri, who was or is a German citizen who was kidnapped and tortured in Macedonia as well as in Afghanistan, and the role of the different countries in that torture and the response of the Inter-American system as well as the European system of human rights to that case. And then, of course, we looked at business and human rights. We looked at the guiding principles of business and human rights, the UN guiding principles that came out in 2011, and we looked at specific cases of violations by businesses of human rights. So it was a general overview of different human rights violations and how the different systems have dealt with them. So we looked at the evolution of the different systems in terms of how the systems protecting human rights, if they have evolved in a way that is ensuring more rights or how they have evolved. So we really looked at it critically, and we can say that the European system has really developed more aggressively and has obtained more recognition than, for example, the inter-American system. The inter-American system has evolved in a positive way, but the role of countries recognizing the importance of these systems is the key ingredient to make them successful. So that's why now, for example, in the European Union, if a country wants to join the European Union, they have to agree to be part of the human rights system of the European Union. Whereas in the Latin American or the inter-American system, we have countries that are not parts to the system, and that also jeopardizes the ability to have a big impact. So we looked at it critically. We also looked at the role of the UN and trying to identify there were some positive steps in some ways, and in other ways we can see that there are important setbacks in the achievements in the human rights area. And when we looked at business and human rights, right now we have the guiding principles, the UN guiding principles for business and human rights, but they are principles, they are not immediately enforceable. So that also has an impact of not being so effective as a human rights mechanism to ensure that no violations will be perpetrated by businesses. So what we see in the inter-American system particularly is countries getting out of the inter-American system. We had, or renouncing or denouncing the system, for example, Venezuela that was part and then got out, and then other countries that are not implementing. Here, Brazil, for example, is a country that the Inter-American Court decided that the amnesty law was in direct violation of human rights, and to this day, that decision has not been implemented. So these are two examples of countries that have dealt with the decisions or recommendations or with the inter-American system in different ways, and both ways in negative ways, in either denouncing or not complying with the decisions of the court in the Brazilian case. So that has a direct negative impact on human rights.